Hello and welcome everybody. In this video, we are starting with the English explanation of the chapter on judiciary, which is the first chapter of your class 12 legal studies textbook. As some of you have requested, you want me to do the explanation in English as we did in class 11. So let's start. First of all, we need to remember that in India, we have the federal system of the government. We have a central government, and in each of the respective states, we have the state governments. But at the same time, the Indian Constitution has envisaged a single integrated judiciary, which means the Supreme Court, which is the apex body in New Delhi, is the highest judicial authority. There is no other court above it. The decision it renders, it's a final decision. And since it's so important, we need to remember certain dates. Like for instance, it was established on 28th January 1950, and it replaced two important courts, the Federal Court of India and the Judicial Committee of the Privy Council. These two were important when the British used to rule us. Now the Supreme Court has 34 judges and 1 Chief Justice, and when it was established in 1950, it had 7 judges and 1 Chief Justice. After that, certain introductions to the high courts and the district and sub courts are given. You need to remember the first 4 high courts: the Madras High Court in Chennai, Bombay High Court in Mumbai, Calcutta High Court in Kolkata, and the Allahabad High Court in Allahabad. You can remember it as MBCA. Then the district and sub courts, there is one important distinction here that you need to understand. In case of a civil case, the judge is known as the district judge, and in case of a criminal suit, the judge is called a sessions judge. And this is applicable in case of the states which are not metropolitan areas. In case of the states which are designated as metropolitan areas, we have the metropolitan sessions judge. ठीक है, फिर हम चलते हैं towards the structure of courts. उसके अलावा there is nothing to read in this area. Obviously, the Supreme Court at the center, and in each of the states we have high courts. Below the high courts, we are going to study the respective courts under 2 distinct areas. One under the metropolitan area, another in the regular district. In the regular states which are not metropolitan areas. And what are the 4 metropolitan areas in India? Chennai, Mumbai, Kolkata, and Delhi. That's it. And in the civil side of metropolitan states, we have the city council court, and the lowest courts in the civil side is the courts of small causes. In the criminal side, we have the sessions judge, the chief metropolitan court, and the metropolitan magistrates courts. I hope you can understand what I am talking about. We are talking about these things. Alright. And in the district and sessions courts, we have, in the civil side, the lowest court is the municipal court. Above that is the principal junior civil judge court. Below that is the senior civil judge court, which we also call sub court. Below that we have the district court. Right? In the criminal side, we have the sessions court, which is the highest court. Below it, the judicial magistrate court of first class, and the lowest court of the criminal side is the judicial magistrate second class. That's it, nothing else. Next we come to the tribunals. What are tribunals? See, tribunals are called quasi-judicial bodies. Why quasi-judicial or semi-judicial bodies? Because it consists of certain officers without a legal background. That's a sentence that you must write in the introductory part of tribunals. There are 2 purposes why we have tribunals. First of all, to increase the efficiency of the judicial system and to reduce burdens on the courts. There are certain examples of tribunals: the Central Administrative Tribunal, the State Administrative Tribunal, the Telecom Dispute Settlement Appellate Tribunal, the National Green Tribunal. You need to know the one sentences as in the explanation of all these tribunals. Alright? And apart from the tribunals like CAT and SAT and NGT, there are other bodies too. Apart from these tribunals, we have the regulators. Regulators, you see, I've highlighted this definition, so you need to remember these things by heart. Anything that I've highlighted, you need to remember. And remember this for the entire chapters of class 12. Regulators are specialized government agencies that oversee the law and order compliance in the relevant government sectors in India. For instance, the TRAI, Telecom Regulatory Authority of India. That's the regulator of the TDSAT. This one. Let me show you this one. The regulator of TDSAT is TRAI. Ho gaya? Then we come to the salient features of the Indian judiciary. There is nothing much here. There are two important concepts, and these two things you need to remember. First of all, the common law jurisdiction that India has, and the adversarial model of dispute resolution. See, in the common law jurisdiction, what does it mean? Since we have inherited the judicial legacy of the British rule, in the system of common law jurisdiction, the decisions, orders and judgments of the courts, they help in creating laws. So the courts play a vital role in creating law. And just as we have the common law jurisdiction in certain countries other than India, they also have the civil law jurisdiction. Civil law jurisdiction as in the courts cannot make law. They cannot contribute in forming the legislations. Only the executive and the legislature, more specifically, they can make laws. There are examples of such countries like we have Germany, Italy and continental Europe. You can see the examples, I guess, on the screen. And that's the first feature. You need to remember the difference. Okay, common law jurisdiction and civil law jurisdiction. Though civil law jurisdiction is not there in your textbook, but I think in most of your schools it will be done by the teachers. Apart from that, the second feature of the Indian judiciary is the adversarial model of dispute resolution. You will learn in details about this in the chapter on arbitration, so don't worry about that. What happens in the system? Lawyers, they represent the disputing parties in front of a neutral judge. The judge is playing a passive role. Passive is a key word here. Okay? And the judge decides the case on the basis of the merit as presented by the lawyers. Here the role of the lawyers becomes extremely important, you can understand. And just as we have adversarial model in India, there are other countries which follow the inquisitorial model. There the judge plays a proactive role. They're extremely active. They probe into the matter just like the police. I think these kind of differences you will do in your class too, and that's the crux of the matter. Next we come to two important law officers in India, and these article numbers are extremely important, so please pay attention to this. The Attorney General of India, the details of the provisions regarding his service conditions and his appointment is laid down in Article 76, and in case of Advocate General it's Article 165. So let's start with Attorney General. He's called the first legal officer of India, and we need to remember 5 things about him. First of all, who appoints the Attorney General? The President. How? See, he has to be qualified to be a Supreme Court judge, and then only the person can be appointed as an Attorney General. Just a minute. Right. Now, what is the duty of the Attorney General? The duty of the Attorney General is to advise the government, the central government, on legal matters. That's his job. Then he has a special right, the right to audience. What does it mean? First of all, he can participate in the parliamentary proceedings and can appear in the courts too. But while he is participating in the parliament, he doesn't have the right to vote. Other members of the parliament, the MPs, they have a right to vote in any proceeding or while passing a bill. But this person, the Attorney General, doesn't have such concurrent rights. He simply can participate in the proceedings and can also appear in the courts for discharging his duties. And we have 2 other posts which are not constitutional posts, but they are governed by the parliamentary rules. The posts are Solicitor General and the Additional Solicitor General. These two individuals, they help the Attorney General in discharging his duty. I'm sorry, the screen is sometimes, appearing to be dark. I'm trying to prevent that from happening. Alright, next we have the Advocate General, Article 165. He is the legal officer at the state level. And there are certain things that we need to remember here. First of all, who appoints the Advocate General? The Governor does so. The qualifications of the Advocate General: he should be qualified to be a High Court judge. The duty of an Advocate General: he's a chief legal advisor. Just as the Attorney General advises the central government, the Advocate General advises the state government. They also represent the state in case of dispute. Tenure of the Advocate General: see, this is a little ambiguous. this provision is mentioned in the Constitution as such that the governor, up till the governor deems fit, the Advocate General can continue in office. Obviously, there are scopes of abuse of power and corruption here, but that's true. And to help our Advocate General, there are additional Advocate General in all the states. Done. Next we come to constitutional roles and impartiality. If you are not being able to understand something, then please feel free to comment. I know that very less number of subscribers will be seeing this, but whoever is doing it, please let me know what you are unable to understand. Otherwise, it's difficult for me. Okay? So the first thing here, and we are now coming to the more important portions of the chapter. Article 50. Article 50 lays down the rules of the independence of the judiciary. Article 50 confers an autonomous status to the judiciary. First of all, it's important for the maintenance of the rule of law. It ensures good governance and it creates a free and fair society. These 3 points. Alright, see, I am giving you point wise. You need to elaborate. Just put this in a sentence and write your answers for your exam and you will be done. So, in Article 50, you need to remember what it is about, the autonomous status of judiciary, and the 3 reasons why this is granted. Then we come to the 6 reasons for granting a special status to the judiciary. When I was reading this chapter in my class, then I had maximum difficulty in remembering all these points in order. So I have written this in a precise way in the same page. I don't think it will be a difficult thing for you. First of all, its role as a watchdog in a democracy. It watches and monitors the other organs. Like Article 20 subclause 3, which confers the accused, anybody who is accused of any crime, has this legal safeguard that he cannot be coerced by the police to confess his crime. That's the right against self-incrimination. You will know this in detail in the human rights chapter, which is there in term 2, I guess. So, Article 20 Part 3 prohibits or limits the right of the police. The police in the country has the right to, convince the accused persons to confess their crimes, but they should not violate their human rights. That's all. So, all these roles are going to be performed by our judiciary. Then we come to the second reason. Independence of judiciary is important to ensure that the constitutionally guaranteed rights are interpreted as per the true constitutional philosophy. Any philosophy of the constitution, it has to be remembered. Simply, if we apply the law technically, then it goes against the basic spirit of the constitution. That's the meaning. And this is a beautiful feature which is often reiterated in many of the cases, like in Keshavananda Bharti case, in Maneka Gandhi case, or in all these cases the Supreme Court has said this. In M.H. Haskar case, that if we technically interpret law, then it's not right. We have to interpret it as per the constitutional philosophy. There is an example given here. The Constitution grants the citizens the freedom to speak in public and peacefully assemble. Alright. And the judiciary also acts as a guardian of fundamental rights. Independence of judiciary was carved out when India was transitioning from a feudal to a democratic system. And we are given a range of civil and political rights. We are given a range of economic, social and cultural rights. That's the key point. You need to elaborate on it. That's it. Alright. Like for instance, civil and political rights include the right to freedom, and economic, social and cultural rights include the right to fair wages. These things, religious rights, all these things are there. Next we come to the fact that an independent judiciary gives an expanded meaning to Article 21, right to food. It's a new right. It was not there when Article 20 was made as such by the constitution makers. Our great constitution makers like B.R. Ambedkar and all the rest of the leaders, they drafted the constitution for us, and such specific rights were not there under Article 21. Some basic rights like right to liberty, these things were there. But with time, our judiciary is being empowered to create new rights, like the right to food. I am sorry if you can hear any background noises of honking, but yes, the right to food is a new right. In your textbook, there is an example of a street vendor who has to get out on the street for selling fruits or vegetables. because he has a right to do so. He has a right to food. As a result, getting out on the street is also a part of his Article 21. हो गया. Then we come to the fact that the independence of judiciary is linked to the granting of a free and fair trial to the offenders, to the accused. This becomes important in two cases: when the accused is a foreign national or the accused is a terrorist. No matter who he is, who he or she is, the person needs to be granted the right to fair trial. It doesn't happen when they are terrorists, but they too should have human rights. That's what the constitution makers wanted. You can understand such noble philosophy needed to be applied in the actual scenarios. That's why judiciary becomes important, and its right to enforce the citizens' rights, citizens as well as non-citizens' rights, becomes important. Last point of this entire thing is that the independence of judiciary is vital for respecting the due process of law. Now, what is the meaning of it? Due process of law. Due process of law means a state must respect the legal rights of the citizens and should conform to the norms of liberty, fairness, and fundamental rights. These three things are important, and the state must respect these three things, and also the legal rights of its citizens. Because of all these three reasons, because of all these, not three, 6 reasons, independence of judiciary becomes extremely important. Alright, then we come to the role of judiciary. Here we are going to study about 5 things, but the first 3 most important jurisdiction refers to the original jurisdiction, advisory jurisdiction, and appellate jurisdiction. Articles. Please remember the articles here. Sorry, for some technical details I had to pause the video. So here we need to remember 3 things. The Supreme Court and the Indian judiciary, to be more precise, it performs the role of an adjudicator, interpreter, and an advisor. And the article number of the original jurisdiction is Article 131. That of the appellate jurisdiction, if we are going in order, appellate jurisdiction is Article 136, and advisory jurisdiction is Article 142. Okay. So under original jurisdiction, what does it mean? It means that any disputes which is original, any dispute between the union and the state, or between one or more states regarding, say for instance, the sharing of river waters, these disputes can be brought directly to the Supreme Court for settlement. That's why it's called original jurisdiction. What happens in other cases? So other cases which are not of such importance, they are first taken to the lower courts like the district courts, then to the high court, then to the Supreme Court. Here, such cases which are extremely important, which involves question of law and order, questions of general public importance or public interest, such cases are brought directly to the Supreme Court. That's why these cases are called original jurisdiction. Next jurisdiction is the advisory jurisdiction. It's also called presidential reference. It's given in the 3rd place in your textbook. Here what happens, the president may seek advice from the Supreme Court on questions of public importance. However, it's not binding on the Supreme Court to answer, especially if the question is on socio-economic nature or it's political in nature. In these 2 exceptional situations, the Supreme Court refrains from giving an advice, and though not mentioned in your textbook, it's also a mention in the Constitution that it's not binding on our president to accept the advice of the Supreme Court. It's entirely on them. In the case of appellate jurisdiction, which is Article 136, it can be invoked by a High Court certificate. It can lie against any judgment, final order, or any decree of a High Court. What this means is that suppose the High Court of any state has given a judgment, and the person who thinks that the particular judgment has been disproportionate to his or her interest, they can appeal to the Supreme Court to change the decision. That's the appellate jurisdiction. But such issues should have a substantial question of law, and the court will decide upon certain things. Apart from that, we have 2 more jurisdiction, which is the writ jurisdiction. It can be invoked by Article 32 of the Supreme Court, and the PIL, the next jurisdiction. It's an extra constitutional jurisdiction. What happens in the writ jurisdiction? Our fundamental rights, the fundamental rights of the citizens, If they are violated by the government or anybody, by the executive, then we can approach the court and they will enforce our rights through writs. There are examples of writs we are going to do right now. For instance, mandamus, prohibition, etc. These are writs. And in case of the writ jurisdiction of the Supreme Court, the article is 32. In case of the High Court, it's article 226. हो गया. In case of PIL, it's called Janhit Yachika in Hindi, and the Supreme Court has relaxed its locus standi. What does it mean? Locus standi means right of a party to appear in a court. Traditionally, what happens when two parties are in a dispute, or one party whose right has been violated, they appear in the court, they approach the court. But in this case, apart from the parties involved, third person like us, we can approach a court on behalf of the victims whose right has been violated, because the victim belongs to the lower rungs of the society. They're poor, they cannot enforce their rights. For instance, they're in jail. We as public spirited citizens or certain civil society organizations, they can approach the court for enforcing the rights of the citizen. This is called judicial activism of the Supreme Court. They can be enforced by writs or by writing letters to judges, which are then converted to petitions or letters. The first PIL was the Hussainara Khatun versus State of Bihar case. It was fought in 1979. I hope you can see this. This 1979 is important. This case is also important. The name of the judge here, P.N. Bhagavati, is also important. Apart from him, there was another judge, not important here. So you remember P.N. Bhagavati, name of the case. This was the first ever PIL fought in India, and the date is extremely important. It's a little dark here, 1979. हो गया. Now, what are the several issues that are being encompassed within the ambit of PILs? First of all, it includes socioeconomic rights, legal entitlements, environmental issues, and political reforms. These four things. Just close your eyes, learn these things, write it. Don't forget this. That's what I want to say. Socioeconomic rights is in our right to fair wages. Legal entitlements, as in certain legal rights granted to the citizens. Environmental issues, we also have a right to be there in a clean environment. Sadly, this is not put into practice, but definitely the Constitution wants to grant us this. And political reforms, this is often done by the Supreme Court. It advises the governments to bring out certain reforms. And we also need to remember certain characteristic of litigation. First of all, their non-adversarial litigation. Adversarial, what happens here? We have just now discussed the adversarial model of dispute resolution, wherein there is a neutral judge and the parties represent the clients. Here what happens in non-adversarial litigation, and that pits the interest of one party over another. There is no such thing. Often it's the victims who are the victims are exploited by the state. That's why we need to enforce their rights. There is no dispute between parties. There is simply an allegation against the callousness of the state authorities. Like what happened in the Hussainara Khatun case. If we discuss that, in the Hussainara Khatun case, there were thousands of inmates of the Bihar Jail. They were imprisoned for so many years that was in fact more than the year if they were actually subjected to proper legal trial. That's why it's an inhuman condition in Bihar back then. That's why such things are dealt with by PILs. Then it has expanded the rights of third parties too. And the second characteristic is that it's based on the tenets of citizen standing and representative standing. It increases the third party rights that I said right now. What it means, the citizens are granted explicit rights to enforce the rights of their fellow citizens who cannot enforce theirs because of economic or other disabilities. That's why it's expanding the right of third parties. We can approach the court even if we are not subjected to any wrong things. Certain people debate against this, that this is not right. It has increased the burden on courts. Third, it's modeled on the remedial nature. It aims to create a dynamic, welfare-oriented model of judiciary, and it's creating new rights for us. It is democratizing the citizens' rights, the citizens' access to the courts. Last but not the least, it has strengthened the judiciary. Obviously, the judiciary in our country has been strengthened because of PILs. And obviously, if there is something which is so good, there must be some flip sides of it, some negative points of it. PILs too are misused by citizens for private gains, for encouraging frivolous litigation on unnecessary issues, and over activism of the judiciary. Sometimes the judiciary has allegedly stepped onto the shoes of the executive and the legislature, and that's also not right. The three organs need to perform its functions autonomously, independently. It need not interfere in the functions of other organs. Obviously, these three are the flip sides. Now we come to judiciary, the second part of it, the high courts and the lower courts. We have district courts, the courts of the lowest instance. High courts to have writ jurisdiction and independence and impartiality of the judiciary. That's a constitutionally granted provision. You can see here, it's a constitutionally conferred protection. ठीक है. Then there is a theory, theory of constitutive mechanism of independence of judiciary, and it's defined in terms of independence of judges. If judges are performing their role in an independent way, then only the judiciary can be truly autonomous. Judges ought to function in an unbiased manner, given by Simon Shetreat. But we need to understand that independence and impartiality is two distinct concepts. Independence refers to the status of the judiciary, and impartiality refers to the constituent actors and their mindset. I think you can understand the difference. And then we have some provisions of the independence of judiciary. First of all, it cannot be curtailed by the parliament. The rights of the courts, they cannot be taken away by the parliament. They have a vast appellate jurisdiction, and there are many supplementary powers too. And obviously, if we are considering independence of judiciary to be impartiality of judges, then we should ensure that judges are performing their role in an independent way. First of all, they have a security of tenure. In case of Supreme Court judges, their retirement age is 65 years. In case of High Court judges, their retirement age is 62 years. They cannot be removed except for a special procedure which is called impeachment, and there are only two grounds of impeachment: proven misbehavior and incapacity. Only write these two things, no other things, please. People often make mistakes here because they try to explain these 2 points. Don't explain these 2 points. I think you need to write all these points the way I've written and the way it's written in the textbook. So only write proven misbehavior and incapacity. These two are constitutional terms. Okay? Then their salaries and their perks, they are not subjected to any vote of the legislature. The salaries are taken from the Consolidated Fund of India in case of Supreme Court judges, and the Consolidated Fund of the state in case of the High Court judges and the district courts too. And their behaviors, their conduct, their decisions, they cannot be discussed in the floor of legislature or anywhere. They have that much right. The Supreme Court has its own establishment and complete control over it. It elects its own members, it controls their own finances. Everything is given to the judges and the judiciary. That's why we can easily say that independence of the judges, it's a constitutionally conferred protection. And definitely, if judiciary is such a prestigious organ, and if the if the independence of judges are so important, then obviously we need to appoint the best of the persons, the most eminent persons in such positions. So first, let's deal with the Supreme Court appointment of judges. In the Supreme Court, the article which mentions about the appointment of judges is Article 124. A judge of the Supreme Court has to be appointed by the President in consultation with other judges. Qualifications of a Supreme Court judge: first of all, the person has to be a citizen of India, has been a High Court judge for at least 5 years, or a High Court advocate for at least 10 years, or a distinguished jurist in the opinion of the President. Here we have "and" only in one place. In the rest of the places, you need to write "or." Citizen of India, that's a must in all the cases, and a High Court judge, or a High Court advocate, or a distinguished jurist. Alright? And in case of a High Court judge, it's 5 years. High Court advocate, it's 10 years. We come to High Courts. Article 217 deals with the rights of the High Court judges. Not only rights, but also appointment. And here also, the High Court judges are appointed by the President in consultation with the Chief Justice of India. And the governor of the state is also consulted. Qualification of such a judge of the High Court: must be a citizen of India, or has held a judicial office in India for 10 years, or has been an advocate of a High Court, or one or more subcourts in succession for 10 years. Here, for both the options, we have 10 years. unlike the Supreme Court qualification. Alright, now we follow the collegium model for appointment of judges. I know you will be a little tensed here because collegium is a little complex, but don't worry, once I explain, everything will be easy. Acha. So before we do the collegium model, let's learn one more article. Article 124 for Supreme Court, Article 217 for High Court, and in case of sub-courts, we have Article 233. Just print this in your mind. Just have an imprint of this in your mind. Don't forget this. And in case of the sub-courts, judges are appointed by the governor of the states in consultation with the High Court. The person's qualification includes should be a staff of the judicial service in the state or has a 7 years experience as a lawyer in the bar. That's it. Now we come to the collegium model. And in the modern days, the current practice of appointing judges is entirely by following the collegium model. Appointment of a Supreme Court judge, there are 4 steps here, and the collegium of the Supreme Court is comparatively easy. Here, seniority of the judge plays a very important role. First step, Chief Justice of India at the center, in consultation with 4 senior most judges. Just a second, yes. The Chief Justice consults 4 senior most judges to appoint the judge, and this recommendation is sent to the Union Minister of Justice. He then sends this entire thing to the Prime Minister. The Prime Minister advises the President to appoint the judge, and obviously seniority of the judge plays an important role in appointment. Ho gaya. There is nothing else in the collegium model in the Supreme Court. Then we come to the High Court judges. High Court collegium model. There are 2 collegiums here being formed. One here, one here. What happens? First of all, Chief Justice of the High Court. So this is a different thing. This is a different thing. Here, Chief Justice of India, Chief Justice of the Supreme Court. Here, it's a Chief Justice of the High Court. He, in consultation with 2 senior most judges. Here we have 4 judges in case of Supreme Court. Here we have 2 judges. The Chief Justice of the High Court, in consultation with 2 senior most judges, sends their view to the Chief Minister of the state and the governor. They then send this entire matter to the Union Minister. Directly they send it to the center. Union Minister of Law and Justice. The Union Minister of Law and Justice send his or her view to the Chief Justice of India. Now again we have Chief Justice of India, and again there is a collegium of 2 judges, 2 senior most judges of the Supreme Court. This entire material is then forwarded to the Union Ministry of Justice. Again, this is a repetition. I have given 2 points here and here. Repetition of the same person. Again, we have the Union Ministry of Justice here. He then advises he then gives the material to the Prime Minister. The Prime Minister advises the President to appoint the judge of the High Court. There are collegium in 2 places, in this, and in these cases 2 senior most judge forms the collegium. Once in the High Court, another time in the Supreme Court. Done. Collegium model is absolutely done. I hope you could understand. Now, tracing the historical debate on the issue of appointment, obviously if the process is so complex, then definitely there will be certain issues. There was a 3 judges case which has decided to form the collegium model. Now the 14th Law Commission report of 1958, under the guidance of the first Attorney General in India, who was M.C. Setalvar, yes, it mooted as in brought into sharp focus the problems about appointing the judges to the Supreme Court and the High Court. They said that many appointments are made on political, regional and communal grounds. So we need to have some other mechanism in place. There was a series of judgment, the first judge case, second judge's case and third judge case, in order to decide the formation of the collegium model. These three cases led to the formation of the collegium model. The first judge's case was fought in 1981, then it was 1993 the second judge's case, and third 1998. In the first judge's case, it gave primacy to the executive, as in the president, the prime minister, they were given more importance as compared to the Chief Justice of India or the other senior judges, and that's wrong, definitely. The Chief Justice of India's recommendation, it was claimed, can be refused for cogent reason. If the reasons were reasonable, then it can be refused. And obviously, it's not a very good decision. Then there were several, wrong appointments. As a result, the second judge's case was fought in 1993. The Chief Justice of India, his opinion after the second judge's case, it was given a lot of importance. And this decision in 1993 was supported by only 5 judges, and the remaining 4 judges of the 9-judge constitutional bench, they didn't support the decision. So definitely we have certain doubts too. But because the majority of the judges, 5 out of 9 judges were supporting this, so we can say that the decision was passed. And at last we have the third judge's case. It was a presidential reference. Right now we have learned about the presidential reference. Quickly write in the comments, what do we mean by a presidential reference? What's the other name? What's the name of the jurisdiction? The third type of jurisdiction which we learned, I'm giving you this hint, write it down. Alright, so it was in 1998 that this case was fought, and this case, it gave a very beautiful line. It stated that the appointment of the judges, it's an integrated, participatory and consultative process. See, it's an integrated, participatory, consultative process. As a result, we have to give importance to whatever the executive is saying, as well as whatever the judges and judiciary is saying. Consultation is extremely important here. That's what is written. Next, we come to the Judicial Appointment Commission. It was an institution which aims to replace the collegium model, and it has to be formed by the Chief Justice of India as a chairperson, 2 senior Supreme Court judges, the Law Secretary as its convener, and 2 eminent persons nominated by the Prime Minister, Leader of Opposition, and Chief Justice of India. Here too there is a collegium. My goodness. Alright. Then we come to judicial training. These are subsections. I have written this in a precise way. So if you are liking this video, so please give my video a like, and you can subscribe if you have already not done, and you can write a good comment if you think that the explanation was okay. Right. So we have the National Judicial Academy in Bhopal. It was established in 1993. There are 2 aims. First of all, judicial reforms, and then research support services. And under this, we have seen that in 2006, they adopted a National Judicial Education Strategy, which seeks to enhance the online skills registry of the judges. ठीक है. In judicial training, we have nothing much to do. Just remember the name of the National Judicial Education Strategy of 2006, and you need to know the National Judicial Academy, which is in Bhopal. That's it. Next, the more important part is retirement. Supreme Court judges retire at 65 years, and High Court judges retire at 62 years. These things are known to you. And there were 2 bills, in fact, the 114th Amendment Bill of 2010 and the Venkatachalya Committee of 2000, the year 2000. These 2, one is a committee, another is a bill. So these 2 things, they are trying to indicate that the retirement age of judges in India has been a little early. We need to have a little more changes in the retirement age of judges. The retirement age was debated explicitly during the 2010 bill, which seeks to increase the retirement age of High Court judges from 62 to 65 years, but it's still being debated, and it has no effect. Acha. Now here we need to remember one more thing. See, the 114th Amendment Bill is about the High Court judges, and the Venkatachalya Committee, it is about the Supreme Court judges. You should never mix up these 2 things. That's the only important thing you need to remember here. And if we are considering the retirement age of the judges of India, and if we compare it with the global standards, then the retirement age in India is pretty low. And as a result, many senior lawyers decline to take up judgeships. That's why we need to increase the retirement age. But there are some positive things too, like when we are young we excel in most of the things. When we are old we cannot do things with that much efficiency. That's the reason why we have a low retirement age. Next, the next thing is removal of judges. Obviously everybody in a country cannot be good. There are people who abuse powers, who are corrupt. What happens if such a person is appointed as a judge? We have a process called impeachment to remove such persons, and there are only two grounds. We know the grounds, we won't do it. You already know it. These two are the grounds. There are 6 steps in the process of impeachment. It's a little lengthy process, but don't worry, I've given you the notes. You can remember it. First of all, there should be an inquiry by a committee of 3 members, of which 2 are judges. This committee will inquire into the complaint against the judge. Then the recommendation of this particular committee is going to be sent to the Chief Justice of India. Chief Justice of India will then advise the President. The proposal of the impeachment has to be introduced in the Lok Sabha with 100 MPs and 50 members of Rajya Sabha. Alright, the copy of the impeachment process is to be given to the concerned judge against whom the complaint process is being debated in the Parliament. And the motion has to be passed. A very important thing, the motion has to be passed by 2/3 of the members present and voting. A must mention provision. Okay, a must mention provision in your answers. You should write this, otherwise you will get a 0. Now the formal announcement has to be done by the President. This is also important. These are the 6 steps. Just learn it by heart. Alright. And this entire process is governed by the Judges Inquiry Act. This act is also very important. Judges Inquiry Act of 1986 and the Article 124 Part 4. See, Article 124 deals with the appointment of Supreme Court judges, and Article 124 Subclause 4 deals with the removal of judges. But in India, we don't have a popular history of impeachment much. It was successful only once. Justice Soumitra Sen of Calcutta High Court, who was a Chief Justice back then in 2011, he was removed for misappropriation of funds. But this was technically, it didn't happen because he resigned. But if the question is about impeachment and the example in India, then you will write about Soumitra Sen. And in case of Justice V. Ramaswamy, this also couldn't be passed finally. In 1991, Justice V. Ramaswamy, the Chief Justice of Punjab and Haryana High Court, there was a motion of impeachment which was introduced against him. And you need to remember this, how can we remove district judges? First of all, they can be removed in consultation with the state government, and High Court too needs to be consulted. Now, we come to a very interesting part of your syllabus from which you will get many questions in your final boards. Just, you can write it from me. See, wherever I've written this D thing, just remember, you need to remember the definition by heart. What is judicial review? Judicial review refers to the legal doctrine or the principle whereby the court can examine or review an executive or a legislative act, law, decision, etc., and determine whether it's incompatible with the Constitution. So what will they do? What will the court do? They will declare any decision of the Parliament or the executive which are unconstitutional. They will be declared null and void. They cannot be enforced. This much power is granted to the judiciary. In India, we have explicit judicial review powers given to the judiciary. Similarly, we have such powers in USA, France and Canada. But in UK, the judiciary cannot do it. Basically, they follow parliamentary supremacy. As a result, such concurrent provisions are not there in the hands of judiciary in UK. But in India, we do have judicial review. Acha, theek hai. So now we come to 2 important legal doctrines. One is on the separation of powers, another is on the division of powers. What's the difference? Basically, apparently it looks like the same thing, but it's not the same. Why? Because separation of powers is the horizontal separation. It's a horizontal distribution of powers. Horizontal as in like this. It's a distribution of powers between the 3 similar organs. 3 similar organs kya hai? we have the executive, the legislature, and the judiciary. These are the three equal organs of the government, equally important organs, and they have powers distributed amongst themselves. And what do you mean by division of powers? Division of powers is the vertical distribution of powers between the central government and the state governments. That's why we are called a federal country. India is a federal country. This is not under division of powers, this is under separation of powers. What's there? Separation of powers ensures that each branch, all these three branches has distinct powers and responsibilities based on the organizational scheme of the constitution. You see, sorry, just excuse me for this. Yeah, that's the provision given in the constitution, and you need to remember this definition verbatim. Okay? And what are the advantages of this doctrine? First of all, it allows for liberty, it promotes efficiency, and it facilitates democratic discussions. It enriches our democracy. These are the three benefits of the separation of powers doctrine. And division of powers advantages are particularly the same. Before doing that, let's look into this. In India, we have three organs of the government: legislature, executive, and judiciary. The legislature it includes the Lok Sabha and Rajya Sabha. Executive includes the Prime Minister, the President, the bureaucracy, and the judiciary includes the Supreme Court and the sub-courts. Then, let's do the division of powers. The definition of it stipulates and delimits subject matters or items on which the federal and the state governments have powers to make laws. We are doing nothing, we are just referring to the three lists here. That example you need to give in whatever answer you are writing about division of powers. It stipulates and delimits the subject matters. For instance, the three lists, it specifically mentions the items on which the center or the state can make laws. What are the three lists? If you remember, we have the state list, the union list, and the concurrent list in the 7th schedule of the constitution. There is nothing else here. Now, the scope of judicial review, there are three things here, three scopes to ensure fairness in administrative act, and we should ensure this by applying the principles of natural justice, the principle of proportionality, reasonableness. Are you worried because you don't know them? Then I got you. I will be discussing this right over here. Alright, so let's do the scopes first. The second scope is to protect the constitutionally guaranteed fundamental rights. Third scope is to rule on the questions of legislative competence. हो गया? मतलब what can the legislature do? How much area does it cover? The legislature do have certain limits. Article 13, for instance, which is the first part of our fundamental right, it states that the legislature shouldn't violate our fundamental rights. Though in the recent years, a court had said that fundamental right has not been an essential feature in the basic structure, so the court can easily, the parliament can easily legislate against any of the fundamental rights. But obviously, being concurrent with the philosophy of the constitution, we need to remember that the parliament's power to amend the constitution or to make rules, it's not unlimited. It has to be within a fair ambit of area. That's the thing that the courts does. If the legislature oversteps its limit, then definitely the courts step in to limit its power. These are the three things, the 3 points under scope of judicial review. Judicial review is essential for these 3 reasons. Individual and group rights. We were right now discussing about how Article 13, the first part of fundamental rights, prevents the parliament from making unlimited laws or by abridging the fundamental right. That's what is mentioned under individual and group rights. Article 13 subclause 2 elevates the status of fundamental rights by judicial review. Any law made by the parliament against the fundamental rights, it has to be subjected to judicial review. And often these are invalidated or nullified, declared null and void by our courts. And obviously we have already come across Article 32, the writ jurisdiction. It's a writ jurisdiction which we have to learn. Obviously, the writs we need to learn. I have already mentioned, just a second, I'm sorry for this. I have mentioned the writs here in detail, so don't worry, we will do it. These writs are used by the Supreme Court in enforcing the citizens' rights in case the legislature violates our rights, or any governmental authority or anybody violates our human rights. PIL, the last thing, we have discussed PIL, so I'm not going to do it again. It increases and gives us rights. It gives rights to the group to represent the poor individuals. Alright. Center-state relations. Only one article here is important. Article 246. What is it about? The Parliament can make laws on items in the Union list. There are 3 lists in the 7th schedule. You can see the 7th schedule that I have written here. 7th schedule has this Union list, State list, Concurrent list. Alright, Union list is list 1, State list is list 2, Concurrent list is list 3. Union list mentions items on which the centre can make laws. There are 2 examples given in your textbook. Stick to these 2 examples. Don't write extra. For instance, defense and foreign affairs. In the state list, items are mentioned on which the state can make laws. Police and succession. In the concurrent list, both the centre and the state can make laws. Like, for instance, education. See, these are the examples that you need to give. This one, this one, this one. Alright. In the items in the concurrent list, both the centre and the state can make laws. That's it. Fairness in executive actions. Yes. Now the most, important part. That's what I can say. Because you often get analysis-based questions from this part. Matters of executive and administrative actions are subjected to what? To judicial review. And the judiciary interprets all these things on the basis of some principles of natural justice. That's how they can interpret the fairness in the actions of executive. There are 5 things here, I'm sorry. Audi alteram partem, the principle of reasonableness, the principle of proportionality, legitimate expectation, and transparency. What is audi alteram partem? It's a Latin maxim which means listen to the other side. Listen to the other side. As in, if there is a decision taken which violates a person's rights, the person has a right to defend himself or herself. There is a historical case here, which is Maneka Gandhi versus Union of India. Details of this is mentioned. Let me tell you, when I did my class 12 project, I mentioned this case, and it was an extremely interesting case because the Supreme Court indulged in liberal interpretation of the statutes in the Constitution. That's why it's interesting. What happened? Maneka Gandhi, we all know, she is a politician and a journalist. Now, she was going abroad, and suddenly she got a letter from the passport officer that her passport was confiscated in public interest. Now, she had appealed to the Supreme Court that this is violating my right to liberty. The Supreme Court said that we must give the victim or the other side a right to defend their views, the right to defend their stance. That's why they have established audi alteram partem. Listen to the other side. What does Maneka Gandhi say? What does she has to say in the situation where her passport is taken? And then eventually all these principles were established. She was given her passport back like this. Then we come to the principles of reasonableness. It states that the action of the executive must be informed with reason. It should not be arbitrary. Suppose I am a poor inhabitant of an area, and the government wants to create a huge bridge where I live. The government has, just asked me to leave from this place. I do have the concurrent right to ask the government why they are taking this decision, why they want to, displace my livelihood, and the government has to do that. That's the principle of reasonableness. Action of executive must be informed with reason. The government has to say that we are doing this because we want to build a bridge in public interest, and they should also give me compensation for this. They should make a residence for me, perhaps. I know these things are not done in the country, in the ground reality, but government, most of the instances, they try to at least help us. That much faith I have in the country. Then we have proportionality. It grants, safeguards to the accused who are convicted of any crime. Their punishment should not be disproportionate and burdensome. Anybody who has been convicted of a crime of theft should not receive 10 years imprisonment. Obviously, the person should be charged a fee and should perhaps stay in prison for 6 months. Perhaps I'm just giving you an example. It's not written in the Constitution or in law anywhere. I'm just giving you an example. All right, legitimate expectation. It deals with due governmental liability. For instance, if a government before the election, if a political party before election it promised the citizens that if you elect me, then I will, make education free for girls. This is just an example. Now, after the election, this political party forms the government and they simply forget this promise. That can't happen. The government had promised us that they will make education free for girls. Now, after they are elected, they have to do it. That's the due governmental liability in legitimate expectation. Transparency is to deal with the secrecy and related inefficiency and corruption in the government. Suppose, like if we take the example of Maneka Gandhi case, a passport officer took her passport and said that the reasons why it was taken, it won't be disclosed in public interest. That's an unreasonably oppressive and irrelevant thing that was done by the passport officer, the executive wing of the government. That's why, in the aftermath of the case, certain principles like ore alteram partem and transparency, these were established. Transparency requires the disclosure of reasons. If you are taking my passport, then you need to disclose reasons why you are doing this. You simply can't say it's in public interest. Right. Next we come to the basic structure. Everybody knows about it, but still you need to remember these things that I have written in bold. Article 368 confers unlimited power to the Parliament to abridge the Constitution. Any part of the Constitution in the wordings of this article can be changed by the Parliament. And Article 13, Part 2, Subclause 2, it states that the Parliament cannot amend the fundamental rights. So you see how these two are contradictory to each other. What happened in the 24th Amendment Act of 1971? It was under Indira Gandhi's government that it was done. It granted unlimited powers to the Parliament to amend the Constitution. So you see, the fundamental rights, the civil liberties of the citizens, they are at loggerheads. We cannot enforce our rights. The Parliament can do whatever it wants. Now, in all the controversies, it culminated in a case, the historical Keshavaranda Bharti versus State of Kerala case in 1973. It was a beautiful case. It's almost the spirit of the Constitution right now, the basic structure of the Constitution. And you can see this thing that I've written, DRSSJ. I've written DRSSJ. It means democracy, rule of law. I'm not writing anymore. Democracy, rule of law, secularism, separation of powers, and this is finally judicial review. You see, this is a basic structure of the Constitution. Don't forget this. All these are the basic structure. DRSSJ. Okay? It's a basic structure. And what was established in the basic structure case was that the Parliament cannot amend the basic structure. It cannot touch the basic structure. It cannot remove democracy or secularism or separation of powers or rule of law. It cannot be done. It cannot amend. It cannot remove judicial review from the Constitution. That's a basic structure, a historical thing that was done. Alright. Now, if you are thinking that how is it relevant in this chapter on judiciary, then you see judicial review is a very important part of basic structure. That's why through judicial review, the courts are going to declare laws passed by the Parliament invalid if it's unconstitutional, of course. That's the relevance of the basic structure case here. It grants the powers to the judiciary. Last but not the least, now your chapter ends here. But since I know in your exams you will be asked questions on the writs, and since you have writs in your chapter, we will be doing the writs. There is nothing much here. Habeas corpus, mandamus, quo warranto, certiorari, prohibition. Those of you who have your class 11 textbook, just open your text. You can easily recall it, but here I have a very precise note on the writs, and I'm going to explain you obviously, so it's not a problem. What's habeas corpus? First of all these are Latin maxims except for prohibition, which is in English. You can see this E here written beside it. Habeas corpus means you may have the body. This writ can be enforced while the court is ordering to produce a detained person. Suppose the police has illegally detained a person, then that person has to be produced by the court by habeas corpus. And this person can also be released if the detention is found to be illegal. That's it. In mandamus, we command. The court is commanding somebody. Commanding whom? A public or a quasi-public body to do something in the nature of public duty. Public duty here is a key word. The court is instructing a executive body or a public body to discharge a duty in the nature of public interest. That's the thing here. Quo warranto means by what warrant, by what authority. Quo warranto can be enforced against a person who is holding an office to which he or she is not entitled to. That's quo warranto. Certiorari means to be more fully informed. This is to remove a suit and adjudicate upon the validity of the proceedings. To be more fully informed. That's it. Prohibition is to stop or to forbid. This can be issued by a higher court to prevent a lower court from dealing with a case over which it has no jurisdiction. You can remember from class 11th. Already I have discussed judiciary with you. So I have mentioned there are some pecuniary limits on the courts. Suppose the lowest court, the municipal court in the civil side, they can deal with a case up to rupees, suppose some 50,000. This is an example I am giving. So beyond that, it cannot deal with a case which has the subject matter of it is regarding a theft, which involves theft is a criminal matter. So let's say a contractual thing where the contract is more than rupees 1 lakh, the municipal court cannot deal with it. So if a municipal court does this by violating law, it's the higher courts, the high court or the Supreme Court, it can enforce this prohibition writ against the lower court from dealing with such a case, because it has no jurisdiction over such a case which goes beyond its limit. I hope this is becoming a little clear in your mind right now. So that's it. This was an example that I was giving in another video. It's not important here. That's it. There is nothing else that you need to remember in this chapter. Just keep in mind that you often get analysis based questions from this portion on writs and from here. I have tried to make this as clear as possible to the best of my ability. If you could understand the chapter well, please don't forget to write a good comment, because it motivates me to do more videos. And don't worry, all the other videos that I am posting in the channel in Hindi, I will make English videos of it definitely for you all. And if you want to see the videos in Hindi, then obviously in the playlist everything is being there. So for today, bye bye. Meet you in the next video.